As Dean of the College of Law, I am excited to help facilitate the expansion of the NRE's presence at MSU. We have hired an executive director who is one of the nation's most respected lawyers in securing reversals of wrongful convictions. She will advance our important work in collaboration with the University of California, Irvine and the University of Michigan. Now, professors, over to you for our program.
Thank you, Dean. We are so excited to be here with you today to tell you about the National Registry of Exonerations. So you've all probably seen stories in the news about people who spent years in prison for a crime that they didn't commit. Some of these cases get a lot of attention, high-profile cases of people spending decades in prison or on death row, who are eventually exonerated of their crimes. But the news cycle eventually moves on until the next big exoneration. What's more, many cases of false convictions just slip under the radar and don't get any media attention, but they should. Every person who is falsely convicted of a crime they did not commit should be counted and have their story told. And the registry's mission is to do just that. The registry's mission is to do just that. It tells the stories of the people who faced a criminal conviction they did not deserve, and it keeps track of data about each and every exoneration in the U.S. So founded in 2012, the National Registry is a unique collaborative research project of the Michigan State University College of Law, the Newkirk Center for Science and Society at the University of California, Irvine, and the University of Michigan Law School. I'm the editor, and Professor Grosso is the associate editor. The registry provides government officials, journalists, attorneys, and the public with authoritative, impartial research on wrongful convictions. The registry has entered more than 3,000 exonerations into its database, each of which is coded meticulously for factors associated with wrongful convictions and accompanied by a thoroughly researched narrative summary of the case. The narrative summary tells the story of what went wrong and how it impacted the person who is wrongfully convicted. So you can see our tagline is "Every story counts," and you can see this reflected in the care with which we prepare every case that we add to the registry. So this is Vicente Benavides, who was convicted of murder and sentenced to death in Kern County, California, who was later eventually exonerated after many years based on very faulty forensic evidence and police and prosecutorial misconduct. So wrongful convictions are, of course, only one marker of the problems with our criminal justice system, but they are a distillation of other problems that have taken place at the front of our nation's most pressing issues, specifically systemic racism and discrimination. We also do work on how race impacts jury selection and capital charging and sentencing. And unlike that line of research, our work on wrongful convictions isn't explicitly about racism, but this work nevertheless tells us a lot about how the system chews up and spits out its the least powerful, and race is a big part of that.
The registry contains thousands of stories of people who suffered the most egregious wrongs. We wanted to highlight one story because sometimes it's the stories that resonate most strongly. We wanted to talk about the case of Curtis Flowers. It puts in stark relief how you cannot study these issues in isolation, how racism continues to play a part in the case. Some of you may know Mr. Flowers' story already. He was the subject of an outstanding podcast, In the Dark, during season 2. You might also be familiar with Mr. Flowers' ordeal from the 2019 Supreme Court decision awarding him a new trial. For those of you not familiar, he was sent to death row for the murder of 4 people in a small town in Mississippi in 1996. He was ultimately exonerated in 2020, but that came only after 6 separate trials. Trials with shifting theories of the case, multiple reversals for prosecutorial misconduct by the Mississippi Supreme Court, and as we like to say, not a court known to be particularly friendly to defendants. Finally, the U.S. Supreme Court's reversal just last year or the year before. Finally, the state attorney general stepped in and took the case away from the local prosecutor and dismissed the charges. We had worked on Mr. Flowers' case after one of his post-conviction teams approached us. Specifically, we combed through all of the available records on his trial, from his trials, to assess whether Mr. Evans, the prosecutor in all 6 trials, was unlawfully striking black eligible jurors from the jury. He was, unambiguously. We've examined this issue in different states, different jurisdictions across the country, and discrimination is ubiquitous in a jury selection, but we had never seen anything like what we saw in Mr. Flowers' case. Justice Kavanaugh actually agreed with us in his assessment when he wrote the opinion for the Supreme Court. If the prosecution had discriminated against black jurors in Mr. Flowers' case, that would be bad enough, right? It would be sufficient to undermine the integrity of his conviction. Accuracy is the whole point of a trial. That's what we teach our students, right? We're trying to create an adversarial process to get to the truth. Here, racism likely led to the actual killer, or maybe killers, going free. They got away with 4 murders. So in addition to working on Mr. Flowers' case that racism infected the selection of juries for his trials, we eventually had the privilege of adding him to the registry, where we got to tell his story.
So you can see this on the entry that we have for Curtis Flowers on the website. And the narrative that I was talking about earlier is next to the picture. And at the registry, we never want to lose sight of the fact that these injustices happen to an individual, someone's son or daughter, friend, father or mother. We want to tell their stories in a way that is clear, factual, and transparent, but that nevertheless shows the human toll of these errors. So this is Mr. Flowers' story. It's a bit longer than our usual entry, but most of the exonerees in the registry did not have 6 trials. So one of our researchers, who's a Pulitzer Prize-winning journalist named Maurice Posley, he combed through all of the proceedings of this 24-year saga to tell Mr. Flowers' story. This narrative summary documents how the evidence that the prosecution presented had shifted and changed from trial to trial, with witnesses recanting and claiming that the police and prosecutor pressured them into testifying that they saw Mr. Flowers near the scene of the crime. Maurice also coded dozens of individual details to be added to our database of wrongful convictions. And you can see some of them here on the right side. It notes the state, Mississippi, the county, Montgomery, the most serious crime of conviction, murder. And towards the bottom, you can see what our researchers had identified as the factors that had contributed to this wrongful conviction.
This is a great example of what we do at the registry. A registry entry on an exoneration consists of a narrative, the story, and then also extensive coding, all of it authoritatively researched, written, and fact-checked, right? Fact-checked. The narrative offers a compelling account of the case, but the coding then breaks each case down into more than 100 specific data points. That allows us to see important trends, informative patterns, perhaps a situation where a police officer who's been misbehaving is in different boroughs or different counties. We can see those patterns too. You can explore this data in a number of different ways, but I think this interactive display that we're just showing you right now is one of the coolest ones. This part of our website allows us to look at the whole country and all of the exonerations you know about, or to narrow down into an individual. So you can see here, Professor O'Brien has narrowed it to the exonerations recorded in California, just like Mr. Carrillo that we looked at before. So you just click on the state like she did, and it will show you that in California there have been 275 exonerations since 1989, with a total of 2,104 years lost to wrongful conviction. When we look at Washington, you want to switch us to Washington? Yeah, I know your geography over there on the West Coast. When you switch us to Washington, you can see that there are 52, smaller state, smaller population, fewer exonerations, 52 exonerations with a total of 266.8 years lost. You can dig deeper. If you go back to California, you can look using the codes on the right-hand side there, my right-hand side. Is it always the right-hand side? You can see, for example, that 26% of the exonerees in California were black and 37% Latino. You can see that murder was the most common crime for which exonerees were cleared, from which exonerees were cleared. You can even look at the factors that led to the wrongful conviction. For example, mistaken eyewitness identification was present in 79 of the 275 cases. You can see at the bottom there, scroll down a little bit. You can see that the picture changes too when she clicks different things on or off. So the graph is by year, and it shows what was the mix of cases, who were the exonerations that were present in each one. So you can see that perjury or false accusations occurred in 182 California exonerations. And you can see that it's something that's persistent, right? It didn't just happen way back in the beginning of our keeping track, but that they continue to take place. Our main database, which begins at 1989, at the dawn of the DNA era of wrongful exonerations, has more than 3,000 entries, actually 3,085 to be exact. They keep adding them. We added 150 exonerations in the first 120 days of the year. That's more than one every day. It's insane, actually. A separate database of exonerations before 1989 has 430 entries that go back to the 1800s. You should know that we post all of our exonerations one at a time on Instagram and Facebook and Twitter. We tell you their stories. We try to get a picture so you can see them as humans. And we give you a link so you can come read the narrative and read the facts. We encourage you to follow us. It's at Exoneration List. We also have monthly newsletters. We have annual reports. We have special in-depth reports on individual issues. For example, in 2017, we did a report on race and wrongful convictions. And one of the challenges that we face is that the information we have, while it's all we have, is always incomplete. We don't know more than we know. We know just enough to know what we don't know. So we did this report based on everything we knew, and until now, it's the only report out there on race and wrongful convictions. So we're going to update it this year. But even that report in 2017 has had an impact. For example, last March, the Ohio Court of Appeals reversed an attempted murder conviction for 2 African-American defendants. They presented newly discovered evidence of their innocence and convinced the court, and so their convictions were dismissed. In the ruling, the Ohio court cited the registry's race report and noted the finding that in the registry data that African-Americans are disproportionately vulnerable to false convictions.
So if we turn back now to the case of Curtis Flowers, there's one remarkable incident that sometimes gets lost in all the other outrageous aspects of this case. And that's that in the 5th trial, it ended in a hung jury, and the lone holdout juror was a black man. One of the other jurors reported to the court that this holdout juror had said something during deliberations that arguably or allegedly conflicted with something he had said during the jury selection process. So then the judge had the lone holdout juror arrested in the courtroom for allegedly having perjured himself. The judge also threatened to have Mr. Flowers' attorney, who happened to also be black, arrested. So these charges were ultimately dismissed several months down the road, but the message was very clear, not only in the courtroom, but throughout the small town where this trial took place. And the next time, at the 6th and final trial, the jury convicted. So we chose to highlight Mr. Flowers' case, not only because it's a horrible and insane travesty, but also because it just demonstrates so starkly how deeply ingrained and insidious, how baked in the racism was that infected his trials. The discrimination in the selection of his juries wasn't separate and apart from the false conviction. There was a reason that the prosecutor did not want black people on that jury. He knew he'd have an easier time convincing an all-white jury to convict based on what really was quite flimsy evidence. So one point I'd like to emphasize is that, because I think it's an important reason why the registry is so essential. Mr. Flowers' story has been told for very good reason, and many of you may already be familiar with it. Lines extended around the block of people who wanted to watch the oral arguments at the Supreme Court. But that is just not true for most or even many of the exonerees. Think, for example, about a story of an exoneree who pled guilty to possessing drugs that turned out to simply be Advil. And they pled guilty because they couldn't make bail and they wanted to get back to their jobs and their kids. Those stories need to be told too. And we have recently expanded the registry to keep better track of these kinds of exonerations.
You know, in particular, we think about these exonerations who maybe took a plea because they had to leave, just like Barb was just talking about. And our groups registry focuses rather on the what went wrong, rather than thinking about each individual case. So in particular, it marks groups of defendants tied together by a common pattern of systematic official misconduct, something that went wrong in the investigation or the prosecution of the cases, something that undermined the system's confidence in the conviction. So usually these cases have all been dismissed by the court and are no longer standing. These cases involved corrupt police officers. They involve careless and poorly supervised lab technicians. You know, someone who's supposed to be carefully, just like we do here at Michigan State, right? Trying to do the lab work systematically and carefully, but they get careless or they get addicted to the drugs they're testing. Thousands of cases come from those. They also come from the overworked courts that are part of our country. All of our courts are deeply overworked and tend to maybe not spend the time they should, particularly on misdemeanors, which are the overwhelming majority of the work of courts. So this, what I was showing a minute ago, was the groups registry. And I can show you in particular, if we go back, so this is the whole registry. We have 30 groups. You can see up here at the top on the registry so far, all the way down. We weren't sure how to name our groups, so we just call them by the state they're in and the year they happened. So here we have the California 2020. And I can just read to you. Judges in Orange County Superior Court vacated the convictions of 53 defendants and dismissed their charges in 2020 after an audit of the Orange County, California Sheriff's Office revealed that deputies failed to book evidence in a manner characterized by accountability, consistency, and reliability. These cases often seem like that, these groups. They read like that. A whole bunch of people where we don't actually know that none of those people were involved. We know that the courts lost confidence in their convictions and dismissed them. The first 30 exonerations that are on the so far include well-known cases. Like you might have heard of the case of the 35 people in Tulia, Texas. Do you remember when that was all over the national news? They received pardons in 2003 for wrongful drug convictions based on the work of a rogue undercover police officer. The pardons came from Governor Rick Perry after the sheriff's deputy was found to have given false testimony and that the district attorney was no better and allowed it to stand. Other evidence suggested that the deputy had falsified reports, tampered with potential witnesses by plying with alcohol, and perhaps tampered with the evidence. Do you remember this case? It was all over the news. The corrupt officer was front and center on local news. Similarly famous, of course, are cases from the Rampart scandal in Los Angeles, which you might have heard of, or the Watts cases in Chicago that recently are filling up the registry. The first 30, though, also include many, many cases that have never been reported, even in the local press. Nobody noticed. These are small crimes and people who didn't have a lot of resources typically. The registry becomes the definitive account of the case, especially now when local newspapers are less and less able or present to cover these cases. Our work investigating and documenting what went wrong becomes the sole account and the definitive account. We've already documented groups' cases from state, rural, and urban jurisdictions. We've documented them from, you could see from that long list, from many, many states. And the only reason we haven't documented here, back to this page, let me switch over. You can see them here. See California, Florida, Georgia, Illinois. I know it's kind of tiny, but hopefully you're at your little computer and can see them. So, when time permits, when our researchers have an opportunity, he will add cases from every state in the union and from rural and urban. And this kind of documentation of systemic errors becomes essential for thinking about the reforms. What is it that would make our system more accurate? What is it that we can use to know to check police officers, to make sure they're providing accurate information for themselves, to keep themselves in check. What are the ways that we can double check our forensics?
So at its heart, the registry is a collection of stories about false convictions and exonerations. And you know by now that a handful of these stories are well known. They're subject of books, sometimes multiple books, feature-length documentaries, even scripted films. But the vast majority of the cases in the registry are little known and little noticed. Even if you consider yourself very knowledgeable about false convictions and read every story in the media that you see about an exoneration, I guarantee you that there are many more stories, probably thousands, that you've never heard of and that you could find in the registry. And it all comes back to our mission of telling every exoneree's story, and it matters to them. We made this short video a few years ago when we learned how exonerees felt about being included in the registry.
My name is Johnetta.
My name is Marquise.
My name's Ray Champagne. And in 1979, I was sentenced to first-degree life in prison for a murder I did not commit.
In 2006, an LMPD detective by the name of Tony Finch came to my friend's house, put me in handcuffs and said, "Miss Carr, as long as you tell the truth, you'll get to go home." I was taken down to LMPD headquarters, left in an interrogation room for 11 and a half hours. I was told I was going to prison for effing life. I'm a danger to society and that he did not want me on his streets.
Being in those facilities with guys that had 30 and 40 years in, I didn't want to, become one of those individuals, especially knowing that I did not commit this crime. And it was evidence that clearly showed that I didn't commit the crime.
45 years in a real angry environment, and I was an angry person. And I can't be angry out here. I can't let them have my freedom. They had my imprisonment. I can't give them my freedom.
In 2019, I was pardoned by Matt Bevin. I got a number from a private phone call, and it was like, "Hey, this is Governor Matt Bevin, this is Ms. Carr," and he told me that he was sorry and that he wanted to right the wrong that was causing my life and that he was granting me a full unconditional pardon. My exoneration number is 2604.
I was locked up 2009, found guilty 2010. So from 2010 to 2016, I still had a life sentence. And I was found not guilty of all charges January 18, 2019. My exoneration number is 2498.
So she did another round of discovery. And lo and behold, the prosecution had withheld several documents and testimony that exonerated me. My exoneration number is 2,653.
I'm Fernando Bermudez, and in 1992, I was wrongfully convicted for a crime I did not commit. In 2009, I was exonerated of this crime and freed. TV cameras were there and newspapers told the story. But who is there after the cameras go away and the pain of a wrongful conviction continues? How often does this happen? And just as importantly, why does this happen? And who gathers the information and stories like mine into a whole that is greater than the sum of its parts? The National Registry of Exonerations in 2012, with the help of goals of creating living archive of wrongful convictions and telling the stories of men and women who survived them, have now included my case. The registry can be used for research, public accountability, and policy change. And it could also lend a verification to the humanity of an actual person who this happened to.
My exoneration number means to me a chance to start the healing process and to create a different path with a number that's attached to justice.
You know, my exoneration number means a lot in the sense of the wrongful convictions that been happening across, the United States. And it's something that should be looked at more.
My prison number was W34850. The W stands for Walpole. My exoneration number is 2,653. The difference between the two, one designated me as a convict, a slave of the state. The other number represents freedom, my exoneration, my re-entry back into a life, a real life, as a full human being.
Wrongful convictions happen. How do we know? Because the National Registry of Exonerations keeps count.
Wait for it. Every story counts. So we love that video. We love to see and hear how exonerees feel about the work that we do, like pretty much every day. We both, Barb and I, work almost every day as part of our work at the law school on the National Registry of Exonerations. Barb, for example, reviews every single case that's been put on the registry, included in the database, every single one since 2016. That means she's checked to make sure it's accurate. She's looked back to the source documents. She's checked to make sure it's coded in a way that's consistent with all the other cases in the registry. This takes hours and hours and weeks. She also spends time almost every day, almost every week, maybe not every day, talking with reporters, saying, no, that's not how you use the registry. Yes, this is what you should look at. Wait, click on this button. But also explaining, what do we know and what don't we know? On top of that, though, our work with the registry permeates our teaching. You could ask our students. I wish I could have them all with us here now. They're all excited. Well, they're doing exams. My students did their exams today, so they're not excited. But they're done with the exams. So our work with the registry permeates our teaching all of the time. So if it's criminal law or criminal procedure, our students know that the system is often right, but sometimes wrong. We also teach upper-level seminars. For several years, Barb has taught an upper-level wrongful convictions seminar at the law school. The class almost always fills on the first day, the very first day, and then the students all come parading through my office. How do I get in? Then I tell them, just go on the first day, she'll let you in. But I teach a similarly popular class on capital punishment, although I don't think it's popular right now because they're finishing up their work for me. But the class wraps up my last 2 days of the course with a 2-day student-designed, student-led seminar on a range of topics on capital punishment. So we could talk about methods of execution, or we could talk about victims and the various roles that victims might have in capital punishment. But by the end of the semester, our students have reached a rare level of expertise on the capital punishment system in this country, where we have it, where we don't have it, what it means, what it doesn't mean. And this year, one of the most dynamic conversations, it happened really just last week, was an intersection between wrongful convictions and capital punishment. And these were students who had taken Barb's class in the fall. They had a very sophisticated understanding of wrongful conviction and how it happens. And then they had also taken our course together on capital punishment. And between the two, they had this conversation that you wouldn't hear repeated almost anywhere else in the country, given their expertise. It was so much fun to hear them, and it's really fun to see them use it as they go out into their jobs. We have students doing all kinds of work, prosecuting and defending, working on capital defense and post-conviction capital defense, working on wrongful convictions in any way they can think of. Even out in the western states, we have a bunch of students out that way. So maybe, I don't know, this would be a good place to wrap up the little overview. And we hope that maybe there's some questions we could answer.
Thank you, professors. We are so fortunate to have you at MSU. You are just two of the reasons why I always say that the best is yet to come for MSU College of Law. Now, we want to bring on Russ White, a prize member of our MSU community, the soul of WKAR, to facilitate the question and answer period for us this afternoon. Russ, thank you so much for being with us.
And thank you, Dean Green, and thank you, Professors O'Brien and Grosso. My name is Russ White, a proud Spartan. I hold 2 degrees from MSU and currently produce the MSU Today podcast. I'm excited to be here to help with the question and answer portion of the program. So let's get to it, and let me remind those of you who are going to ask a question, don't forget to unmute yourself because we've muted you all automatically. And first up is Bob Dreisnack. Bob, please go ahead.
Hi, thank you all. It's really almost impossible to know where to start with a question here after you read the stories that are on the registry, some of them anyway. I haven't read all of them. I would consider myself not knowledgeable in this area, learning, but the initial things I see in here are very concerning because I think they go to the fundamental question of justice and fairness in our country. Something that I was always taught to think the legal system here is as good as it gets in the world. And you see things now that probably create a lot of doubt or concern when you try to think about it that way. But I think a couple of questions that I have that I hope will just kind of get things going is, you've listed so many cases, and we can go look state by state and so forth. How often does this happen, I think was the question Fernando asked in the video. And that kind of crystallized it for me. He asked one other too that really helped. How often does it happen? So to me, what I'm sort of asking is, how many more are out there? And then the second question that I would ask is, how does it happen? And, eyewitness accounts have, for many years, I think, been identified as fundamentally flawed. Doesn't mean that there aren't ever accurate ones, but it seems as if there are many, many eyewitnesses that turn out to be wrong. I think the statistic you said was 79%. So eyewitnesses, I don't know are reliable, but forensic evidence I've always thought was scientific based. Yet it has changed, improved, and was improperly applied in so many cases. Official misconduct, how do you counter that? Resistance to facts, how do you counter that? So I think to summarize the questions, apologize for the detail here, but how many more are out there? And how do you identify them, get to forensic evidence where it applies, identify potential for misconduct and address it and come back after it, and then counter the resistance to facts and the long delays that it seems to take in so many of these cases to sort of get to a point from identification of real issues to exoneration?
So all of those questions.
A lot, sorry.
I would describe them both as the $1,000,000 questions. And those of us who study wrongful convictions, the question that hangs over all of us is, we know we can count exonerations, but exonerations are just a proxy for wrongful convictions, right? We don't know how many people are still in prison or living with the aftermath of a conviction who are innocent and who will never be exonerated or maybe have yet to be exonerated. But we have every reason to think that it's the tip of the iceberg. The number of exonerations in the registry, as great as that number is, that they do not represent all of the false convictions out there. Getting to the point about what you do about it, so I think you're right that eyewitness misidentification is something that we've definitely seen more attention, people paying more attention to and starting to question it. But the thing about forensics, and this is something I've been thinking about a lot lately as I serve on the governor's task force, is it's not it's not just one thing, right? There are some areas of forensic science that's science, right? That it was built scientifically, where we actually have evidence and on which to base it. But there's still other types of methodologies that are presented as scientific evidence that really aren't. So, for instance, bite mark evidence. Bite mark evidence is still admissible in a lot of places. These are cases. Bite mark evidence is basically when they find impressions on a body, and they say that the defendant's teeth match the marks on the body, and therefore they can say that the defendant inflicted the wound. This has sent people to death row, this kind of evidence. And it's junk, right? There is no basis for it. So, on the other hand, if you have two-sample DNA, that's really reliable, right? I mean, yes, mistakes can be made, but it's generally pretty reliable. So there's a whole gamut of different types of forensic evidence, some more reliable than others. But sort of taking a step back and a bigger picture is, how do you prevent this? I mean, one is that we woefully underfund indigent defense. The best way to prevent wrongful convictions is to actually have really solid advocacy at the trial level. And that means access to evidence, right? That often the defendant doesn't have the same access to evidence that the prosecution does. And sometimes there's good reason for that, right? There's certain information that you don't necessarily want to make public. But if you were to compare what a defendant in a criminal prosecution is entitled to see to what a civil defendant is entitled to see if they were sued for money, it's hugely different. If you were to sue me, I could get a lot of information about you. I could get a lot of information about the case so that I could defend myself. Not so with criminal defendants. So I think there's a lot of different things that we could do, but I do think that funding public defense, among other things, I think would go a long way.
I wanted you to add, as a result of your work, aren't some prosecutors actually re-examining their convictions?
Well, I mean, I would like to think it's directly because of our work, but there is there's a new trend. It's still not super common, but there's in the last 10 years or so, there's been a proliferation of something called conviction integrity units, where prosecutors create a unit in their own office to put resources and reinvestigate plausible claims of innocence, so that people who are imprisoned or their family members can contact the members of this unit and ask them to look at the case. It tends to be only in metropolitan areas, just because that's sort of, it doesn't make sense in a small office to have a whole dedicated unit. But what we're seeing a proliferation of these in Wayne County, Detroit. There's been just a couple of years old is the CIU in Wayne County, and it's just done an amazing job. It's produced a lot of exonerations. And the other development that we're seeing that I think is very promising is that for these smaller offices that really don't have the resources to invest into a separate unit for conviction review, there's statewide units, so they can sort of step in for smaller counties that because you don't want the same people who tried the case reinvestigating the case. You need fresh eyes on it. So it's good to have that independence, that independent body. Yeah.
Super.
Did we answer all the questions? Did we answer all your questions? Wait.
Thanks for that question, Bob. And Stephen Hanna, you're up next with a question about prioritizing cases. So please unmute and go ahead. Well, let me ask Stephen's question. Given the large number of people in prison who claim rightly or wrongly to be innocent, and given what I presume are the limited resources of most innocence exoneration projects, how do you prioritize or help your subscribers prioritize the cases that you or they should address?
So, this is a very... So innocence organizations like the Innocence Project in New York, but lots of other smaller ones, often they're law school clinics or nonprofit law firms. They do a lot. They're sort of the engine that drives exonerations, and their resources are often quite limited, and they have to really triage their cases. So often for an innocence organization, they have criteria like you have to have at least 5 years left on your sentence or at least 10 years left on your sentence, because they have to go to the most serious cases where they can do the most good. I think as we develop a more sophisticated understanding of how wrongful convictions occur, I think that helps innocence organizations to better triage these cases and to better screen those cases to find ones that may have, it's not just that the person is innocent or not, right? It's that there's evidence that's available that can show that. Because once you're convicted, it's really hard to get that undone. I mean, I think there's a misperception among a lot of people that if the jury makes a mistake, they'll get it fixed on appeal. And that's not exactly the way it works, right? I mean, if the judge makes a mistake, maybe, but the jury's fact-finding is pretty much left untouched. So for a defendant to be exonerated, they really have to produce a very compelling case of innocence. And a lot of that turns on luck. Do they have access to the evidence they need? Do they have access to the witnesses who might recant? And that usually takes someone on the outside with resources to do that kind of investigation. So I like to think that, I know that a lot of innocence organizations use our work to help them better understand the landscape, and also to hopefully triage, figure out how best to screen these cases, the ones that are most likely to result in an exoneration.
I might add, more recently when we've looked at the group exonerations, there are different sets of priorities and different ways to try to think about who's going to be impacted. And sometimes it's the press that uncovers wrongful behavior that turns into a whole lot of people dismissed. Sometimes it's litigation, private litigation. So I think that the priorities are different when you're thinking about capital murder versus when you're thinking about misdemeanors, or whether you're thinking about a bunch of drug cases that all depended on a single lab. And so I think that the more we know about how to prioritize and how to, because I think it still is the case that we don't know so much more than we know.
That's right.
So we're getting there.
Next is a question from Allison Saros. Go ahead, please, Allison.
Hi, everyone. Thank you for having this incredible talk on exonerations. I am an alum of Michigan State. I graduated in 1992. I am a long-term Los Angeles County Deputy District Attorney turned private defense attorney. And so I am on the front lines, boots on the ground, doing exactly what you are doing. And I am on the board of the California Association of Criminal Justice. And so to both of you professors, I would like to know what I can do and what I can bring back to my organization and to the National Association of Criminal Defense Lawyers to help us get the word out, expand this, do what we need to do from inside the courtroom or working directly with other defense lawyers or with prosecutors in order to help progress what you guys are doing from behind the scenes.
So it's great to meet you and great to hear your question. I think that California has really wonderful innocence organizations that I think have been providing resources and have been working with the General Assembly, almost always with the registry in their hands, right, with the policy initiatives. And I think, so I think that's one thing, is that don't be distant from the Northern California Innocence Project or the California Innocence Project. And encourage people to use it as part of their cases. Think about what we do know as part of litigation. And also to challenge evidence, right? To make experts be experts. Don't believe forensic evidence. If it doesn't make sense to you, it doesn't make sense. And hold a high standard. Take the time, insist on the money, and take advantage of every allegedly progressive prosecutor that's out there.
Yeah, and I would add that a lot of defense attorneys, so there's sort of there's the innocence world and then there's the defense world, and they don't overlap as much as you might think. And when I've talked to people, friends of mine who've become public defense attorneys, And a lot of them aren't really, they don't know about the registry yet, and they're thinking about it, and then they discover and they realize, actually, this can bolster my claim. So if I want to make an argument that I should get to have an expert testify about the fallibility of eyewitness identification, they have numbers they can point to. They can say, look, this is this percentage of these cases had mistaken witness identification. It led to a wrongful conviction. So that often, we're often contacted by advocates who want to, not as often as we should be though, right? We are often contacted by advocates who want to know, like, can you give me data in Louisiana about bad forensics, right? And how it contributed to false convictions, because it bolsters their arguments if they want to get funds for their own competing expert, or if they want to have proffer their own expert about, say, false confessions or mistaken witness identification. I think that, we've been so committed to being a very conservative voice, in the sense that, like, we always try to code very conservatively. Our criteria for inclusion in the registry, we don't make our own judgments about guilt or innocence. We're basing it on the legal findings. I think that lends us credibility, and I think the reason that we've been doing that, even though sometimes it frustrates us, is that we want advocates to be able to use it effectively and have the evidence be seen as credible and trustworthy.
Very, very helpful, actually. I know exactly what to do with that now. So thank you guys very much. I appreciate it.
Dean Green, we've had a question for you come through the chat. And what are some other programs in the Law College like the NRE that you're proud of?
Well, the NRE is very unique, but there are 3 I would mention that are pretty fantastic and nationwide centers of excellence. We have our Immigration Law Clinic that specializes in providing representation to people seeking asylum in the United States, led by Professors Veronica Thronson and David Thronson. We also have our Indigenous Law and Policy Center, led by Professors Winona Single and Matthew Fletcher. Those 2 professors just completed the first ever study of the law of American Indian in the United States. And also, our Indigenous Law and Policy Center also has a clinic led by Professor Catherine Fort that specializes in important questions involving custody of Indian children and their removal from their homes. Also, we have a fantastic project led by Professor Justin Simard called the Citing Slavery Project, which is investigating the role that slave-era cases play in decisions by courts today. And that's a particularly interesting project because Professor Simard leads a team of students who assists with his research. So these are just 3 of a number of others, but we are really excited about these areas of excellence, and it's the reason why we have had an amazing admission season, and we're looking forward to a class of students who will not only know about these projects, but be very excited to participate in this important work.
And a follow-up, Dean Green, how can we get other programs like the NRE at the MSU College of Law?
Well, we are open to programs in which potential donors have an interest. We want to, of course, expand our commitment to social justice. That requires funding, and I think if there's anyone on the line today who has a passion for any program of this nature, our advancement professionals would love to talk with you to see how you might support that work. Well, this concludes our time today together. It's gone so fast. Thank you so much for joining us. We are thrilled that so many Spartans from the Western states were willing to take time today to participate. Your interest in learning more about programs like this at the College of Law at MSU means the world to us. And please.
Let me just repeat the thanks. It's so much fun to, at least virtually for now, get to talk with Spartans out there. We were recently down in Kalamazoo, and we had so much fun meeting our graduates who are doing all kinds of different, practicing law in all different kinds of ways, and so proud to have been here at Michigan State. It's really fun. So it's great to meet you all virtually. Next time in person. It's been raining for days in Michigan.
Yeah, I just echo that. I mean, this is just so much fun. I could talk about the registry. I could have been going for hours about this. So, but you know, I know you're all busy. You have busy lives.
Lunch is over.
Thank you so much for attending.
Well, it's been super fascinating for me to participate in this program, and Barb and Catherine are just two of the many reasons why I'm so proud to be the Dean of Michigan State College of Law. If you have any questions after this afternoon, please reach out to Cheryl Armstrong, Jill Newcomb, Elena Miller, or Taryn Storrs. We will be posting a Learn More slide on the screen shortly with additional information, and we will send you this information as well. Thank you so much, and go green.